could simply say that, okay, even though I'm not financially fit, I don't want my child's grandparent, who is financially fit, who is able to give some assistance, any access, because that will some sort of way give away my right to my child. Mind you now, you're not financially fit to do it, but you would rather have your child suffer because you don't want your child's grandparents to take a financial responsibility.
Someone's more of a custody issue rather than visitation. If someone's not able to provide for their child, that's not whether or not the grandparent has rights to visitation. That's custody.
Well, I was referencing
Someone shouldn't have to give away their rights. That's why. I mean, this goes into other issues, especially with welfare specifically. But someone should not have to give away their rights for the sake of their child.
Well, I mean, to that, yes.
Is the petitioner willing to cooperate with the parent?
Yes.
That's the question.
Most definitely. Most
Can
definitely.
I say that in the ex parte ERG court case, it said no matter the benefit of the child, visitation can't be granted without permission from reasonably fit parents.
Where you find that? Where you read that?
I'll give you the site, 73, section 3D 634, 2011.
Okay.
Ex parte ERG.
This is the Alabama statute? Oh, okay. All right. Well, okay, so what's your question, Your Honor?
You were saying that you got to think of the interest of the child relevant to the parents, but this is saying that no matter the benefit to the child, if the parents are mentally fit and they say that visitation can't be granted, then visitation can't be granted based on the ruling in this case.
Well, while I understand that, I would like to remind everyone here today that we're really ruling, yes, and this will set a precedent, but we're really ruling here for Janie Shores. Excuse me, the grandmother. Edit that out. Okay, so basically what we're going to find here today is that at the end of the day, we're ruling on the constitutionality of this. It's as simple as that. While we understand the ideas that parents do have those rights that kind of supersede the children, the basic constitutional premise of this ruling from you guys today is the visitation, and we're looking at our state statute, and we're saying that number one, is there a establishing of a significant and viable relationship with the child? These are the only two things to you that we have to prove.
Okay, excuse me.
Yes, sir.
In section 1, subsection I, article 3, it states that if one of the parents was relieved of their custody by DHR, then the grandparents on that side are not allowed to get visitation rights to their children. How can you constitutionally back that up when you're fighting for the grandparents of all of them?
Now let's remind you that before that, and let me reference it in its entirety. The provisions of this act are severable, and what that basically means, thankfully, in section 4 of this act, that when it means that provisions are severable, it means that any part of this act declared invalid or unconstitutional, that declaration shall not affect in parts which remains. Simply put, your concern that those people who are deemed unfit to take care of their children, and thus the grandparents cannot take, any claim to their children, that falls when we look at the safety net that was already put in the act. Right. So again, basically, the entirety of our case and the responsibility of the justices rests with these two main obligations, and it is our obligation to prove to you again that there was a viable relationship with the grandparent and the grandchild. That's our first burden. The second burden of our case, is to prove to you that visitation is in the best interest of the child. These are the two main points that determine whether or not this case is affirmed or negated. And because we've clearly shown that there is an established significant relationship, especially when you look at from the years 2012 to 2014, in which the grandmother has actually had a relationship with her grandchild until it was severed, that proves that there was a viable relationship. Our second burden of proof to find in favor of us is shown when we have to tell you that it's in the best interest of the child. Mind you now, yes sir?
Has the child been questioned on the relationship with the petitioner?
According to the facts that all of us have been presented, no. No.
Then how do you determine if the relationship was viable?
Well, I think that we determined that the relationship is viable because we're only able to use the facts that we have. And the facts that we have show that not only did the grandparent and not only the two grandparents have a viable relationship, but we have to do a little bit of inference here, okay? We have to be a little bit creative, considering the fact that we do not have the child's sworn affidavit. So what we have to go on is basically, why would a parent want to do a counterclaim in the first place? The only reason or the only way that a parent could possibly even need to do a counterclaim is if the child had a good relationship with the grandparent in the first place. Because if that child didn't have a good relationship, the grandparent wouldn't even want to make a claim to actually see their grandchildren. And I want to go ahead and cite some more case law for you in support of our case. Let's look at the case of New Lovelace et al. Versus Timothy Copley in Tennessee. Basically, to obtain visitation, the grandparent must prove that the parents oppose the grandparent visitation, that a child will suffer substantial harm if the grandparent is denied, and grandparent visitation is in the child's best interest. The thing is, Your Honors, what we're seeing all across the board, from state to state and from precedent to precedent, and as well as statute to statute, just as our statute in Alabama rules, we must rule with the plurality. We do not need to be the state that goes against the fray. The fact of the matter is, case after case can be cited in which it shows that a child's best interest is paramount. Case after case and statute in every state can be cited, which shows that if there is a harm to a child's emotional state, or if there is a harm to a grandparent's right to see their child, then that takes precedent. The fact of the matter is, in this New Lovelace, Tennessee case, in no way to be understood as condoning the acrimonious and uncooperative relationship that has existed between the parent and the grandparents, and we urge them to refocus on how best foster the welfare of that child and allow this goal to guide their future interactions with each other. Simply put, this is a case of what is in the best interest of the child regarding the visitation. While yes, we have already understood that parents do matter, we're looking at the children here. This is because the parents aren't visiting the grandparents.
Excuse me.
Yes, sir.
Can you explain how a grandparent not seeing them could cause harm to the child, whether that be physically or emotionally?
Perfect. Give me 1 second. Okay, so basically what we're looking at here, the way that an emotional harm can be done is that if you are a person who has established another relationship with the person and that relationship is severed, emotional ties are broken. Relationship ties are broken. So that's the way that an emotional harm can be caused. And this is seen from the lowest level of children to even the highest level in which we deal with our spouses, with our significant others and things of that as well. Yes, sir. Before I move on and exhaust my time, I would just like to show you some more case law and things of that nature in reference and in support of us. I would even like to reference the case law that we've all been presented here. Since we hold that showing of harm to the child resulting from denial, and I'm reading the handout, showing the denial of visitation is a prerequisite to any award of visitation under the Act, that subsection B6 necessarily encompasses that a relevant factor that is an act, therefore facially valid. Holding that the judiciary could adopt a construction of the statute that would uphold its constitutionality. We emphasize that the showing of the harm is not to be outweighed. In fact, give me 1 more second. If so, the court may then weigh the other statutory factors to determine the mode and extent of a grandparent visitation necessary to alleviate the harm of the child without further infringing on the fundamental rights of the parent. So what we're seeing here, like I've already stated before, we're not trying to take away the rights of the parents. However, time after time again, we are trying to extend the rights of the children, because far too often, as the justice has just mentioned, in particularly cases of custody and things of that nature, when we mention custody, we can even refer to that. Children, unfortunately, are not taken into account. And that's a problem, especially when we look at custody cases in which a child would much rather go to one parent, but they're forced by a judge to go to another. These are real issues. And referring back to the case before you today, it is our job to uphold the constitutionality of the new GVA, which is supported because not only was it amended from the old GVA to the new GVA to actually include that a grandparent could cooperate with the parent, implying that a parent's options are taken care of. That takes care of the constitutionality, even though it's not explicitly stated. We even imply things from our Constitution. Therefore, we can imply that through the clause that states that grandparents should cooperate with the parents of the children. That is an inherent, basically, parent opinion taken into account. That takes care of the constitutionality. We've proven to you our burden, which shows that there's a viable interest, as the justice here has pointed out, because okay, basically we've proven the constitutionality through showing that a parent does have their rights included in there. We've proven to you that there is a viable interest because the grandparents and the parents would basically, they wouldn't be in court today if there was not a viable interest in this case. They wouldn't be in court presenting this before you today if there was not some sort of need to make sure that the children in this matter had their voices heard. And finally, we proved to you our burden of proving that there is a best interest of the child. Because again, when you have an established relationship, which over the years, there has been an emotional relationship established, to sever that relationship is terribly egregious. And therefore, we urge you through all of the case law throughout the United States, all the statutes that support this case. We urge Alabama to find in the affirmative and to be more proactive in our nation and not take a step back. Thank you so much.
Just one more.
Oh, okay.
Time's up.
Great job, man.